Look at me. I'm Sergeant Wayne Jenkins of Gun Trace Task Force. I'm assigned to Baltimore City Police Department. I don't care if it's This is on camera, dum-dum.
What if the cops chasing drug lords were secretly running their own criminal empire? In Baltimore, the Gun Trace Task Force led by Sergeant Wayne Jenkins did exactly that. Task forces like this educate officers on tracing illegal firearms to curb violence, yet here, badges masked deeper rot. Wiretaps caught officers coordinating robberies and planting evidence, their voices betraying years of corruption. When Jenkins finally took the stand, his tone shifted from swagger to shame. Was his remorse truth or performance? This investigation exposes just how deeply organized crime can bury itself inside the badge. How does a decorated deputy turn the very evidence meant to protect citizens into a weapon of deceit? In Jackson County, Florida, the name Zachary Wester once carried the weight of respect. He was the patrolman who smiled during traffic stops, the uniform reassurance that rural residents trusted to keep their roads safe. Complaints against him were rare. Arrest numbers, however, were impressive, almost too perfect. Each new statistic polished his image inside the sheriff's office, concealing a routine built on deception. Wester's system was precise. He pulled over motorists for minor infractions, an unlit tag, a missed signal, a wide lane drift, and then transformed those stops into staged victories. Hidden inside his left hand were narcotics he had previously removed from evidence. During a search, a quick motion placed them where they didn't belong. The discovery that followed was delivered with calm authority, a small bag, a questioning tone, an arrest. For the victims, confusion warped into panic. For Wester, another successful bust appeared on the record. Drivers who swore their innocence faced a cruel irony. The person accusing them carried the badge of proof. Under Florida Statute Section 893.13, criminalizing unlawful possession of controlled substances, their denials meant little in the face of recovered substances and sworn testimony. Wester breached this in Section 839.25 on official misconduct by corruptly using his position to fabricate charges, eroding the statute's intent to fairly enforce drug laws. Orange bonds were set, jobs were lost, and children learned to fear police cars on sight. What looked like a string of routine arrests became over time a ledger of lives dismantled. Body camera policy was meant to protect against exactly this kind of abuse. These policies educate deputies on maintaining transparency, aligning with ethical standards that demand accountability in all interactions. Green checkmark. Deputies were required to maintain active recording during searches and arrests. Yet in Wester's cases, patterns formed. Segments of video were missing or incomplete. Some drives held corrupted data, others simply didn't exist. Supervisors initially cited technical error, but after a defense attorney argued that footage had been systematically deleted, the explanation began to unravel. Investigators retraced the gaps, comparing traffic stop timestamps with dispatch logs. Forensic technicians uncovered partial clips buried in digital storage. Moments of footage reemerged, hands-off frame shadows shifting around the suspect's vehicle, abrupt cuts before evidence appeared in Wester's palm. These fragments formed the foundation of a fraud far larger than a single arrest gone wrong. Each restored second widened the moral breach between law enforcement's promise and its exploitation. Victims testified with visible exhaustion. One mother described losing what mattered most, saying she had missed a year and a half of her grandbaby's life while fighting false charges. Those words carried into the courtroom with a gravity that even the defense could not dampen. Wester sat motionless as her voice fractured. When questioned about deliberately turning off his camera, he insisted it was customary policy to disable recording at certain times, a justification that prosecutors quickly dismantled by citing department directives requiring continuous activation during citizen interactions. Throughout the proceedings, Wester maintained his defiance. He claimed he was being framed, repeating, "The drugs were there, I did not put the narcotics here." But as digital analysts displayed the reconstructed footage, each denial folded under its own weight. Recovered files revealed consistent patterns of evidence, handling beyond procedural error. Dashcam overlaps tied his patrol routes to planted contraband. For the jury, the coincidence quotient reached 0. When the final verdict was read, the courtroom atmosphere thickened with quiet disbelief. 19 felony convictions, fabrication of evidence under Section 918.13, false imprisonment under Section 787.02, official misconduct under Section 839.25, and racketeering under Section 895.03. He breached these statutes through deliberate tampering, wrongful detentions, and patterned deceit that weaponized his authority against innocents. He was sentenced to 12 years in state custody and ordered to pay over $100,000 in restitution consequences, underscoring the severe toll on victims and public faith. For many watching, the punishment felt minimal compared to the erosion of trust he caused. Communities once eager to cooperate with deputies now turned cautious, recording every interaction on personal devices, holding their breath whenever sirens echoed down the highway. Reconstruction of Wester's deleted files did more than convict a single officer. It exposed a systemic vulnerability, how easily one person with digital access could sabotage justice. Prosecutors later advised statewide reforms for retention software, emphasizing independent audits outside departmental control. Yet the moral wound remained open. Those expelled from trust rarely returned quickly. If a lone deputy could manipulate evidence without oversight, the next question can't be ignored: what happens when an entire unit turns that corruption into policy? Jenkins and the empire within. What happens when a police unit designed to fight crime becomes its most profitable operation? In Baltimore, that question stopped being hypothetical the moment investigators traced a web of theft back to the city's own gun trace task force. Officially, it was an elite narcotics squad meant to stem the surge of armed drug trafficking. Such units educate members on federal tracing protocols to dismantle trafficking networks, fostering interagency trust. Unofficially, under Sergeant Wayne Jenkins, it became an organized enterprise, officers moonlighting as robbers behind the protection of badges and cruiser lights. Publicly, they were the heroes recovering guns off the street. Privately, they were counting proceeds from stolen cash. Jenkins had crafted the image of a no-nonsense commander. He hit the streets hard, brought results that supervisors loved, and filled reports with marginal details that looked precise, but rarely matched the truth. The paperwork masked illicit activity, false inventories, non-existent informants, and raids that began legal, but ended with pocketed money. Colleagues who questioned discrepancies quickly learned that silence preserved both paychecks and reputations. In a city already struggling with fractured trust, the gun trace task force projected efficiency. Its efficiency, however, was the calculated order of a racket. Inside the unit structure meant no oversight. Jenkins operated with select officers who shared both duty schedules and profit. Parallel accounting tracked stolen funds, often disguised as overtime benefits or miscounted seizure totals. When the FBI began probing unusual bank records tied to narcotics units, Baltimore's police command initially defended its task force. The numbers were high, but so were the reported seizures. Yet beneath legitimate forms lay another balance sheet, entries scribbled to conceal thousands in cash pulled from raid scenes before evidence technicians arrived. The unraveling began by accident. Federal wiretaps planted for unrelated narcotics cases transmitted voices that sounded familiar. Agents played back the audio, expecting neighborhood dealers, but heard coded chatter about splits, drops, and cruise phrases too disciplined for street vernacular. Then one name repeated: Jenkins. Investigators froze the recording and cross-checked personnel lists. The next playthrough left no ambiguity. They were listening to active police officers coordinating armed robberies under color of law. Those recordings became the cornerstone of an unprecedented investigation into municipal corruption. In the transcripts, officers discussed fabricated drug deals and rehearsed arrest narratives to justify stolen property entries. Jenkins led each conversation, his voice steady, assigning tasks, dividing proceeds. The calm tone, devoid of hesitation, struck prosecutors as proof of habit more than impulse. Under federal statutes like 18 U.S.C. Section 1962C for racketeering and Section 1962D for conspiracy, the evidence exceeded mere misconduct. It demonstrated an organized, continuing criminal enterprise operating within a sworn agency. Jenkins breached these by leading badge-shielded thefts, falsifying overtime under Section 1001 for false statements, and planting drugs to frame targets, subverting laws meant to prosecute organized crime. Loyalty inside the task force ran on shared guilt. Jenkins tied promotions and favors to participation,
ensuring collective silence. By pulling every member into the same criminal orbit, he erased individuality. Nobody could confess without collapsing the entire structure. Victims, meanwhile, described encounters straight out of institutional betrayal traffic stops, transformed into shakedowns, homes, raided with fabricated warrants, families humiliated, while officers rifled through drawers. The harm extended beyond stolen money. It consumed belief in justice. When prosecutors overlaid the wiretap data with internal
surveillance timestamps, the match was surgical. Calls about collections aligned with unaccounted for cash from concurrent search warrants. Dashcam intervals showed squad cars parked off-grid during the exact windows when robberies occurred. Each connection tightened the circle until the empire Jenkins built began devouring itself. Confronted with irrefutable recordings, Jenkins entered a guilty plea. Federal sentencing under racketeering guidelines delivered 25 years in extraordinary term for a once-praised officer, plus years of supervised release and forfeiture of ill-gotten gains as direct repercussions for systemic betrayal. The courtroom that day held more than prosecutors and press. There were victims waiting for validation, fellow officers dreading collective shame, and a city audience questioning how long the badge could shield predators. Families testified about lost faith. One relative of a victim said, "Do you trust the police department after what your family has been through?" "No, sir. Never. Can anything change that?" "I don't think so." Those words carried the weight of generations betrayed. The fall of the gun trace task force dissolved the illusion of isolated misconduct. It proved corruption could scale like any business, efficient, structured, profitable. And while Wester's crimes hid behind deleted footage, Jenkins' downfall echoed in permanent audio. One man erased evidence, the other was undone by it. The difference defines how visible truth decides justice and how silence can no longer protect the powerful. The technology that broke the silence. Why are deleted files sometimes louder than recorded proof? In one courtroom, prosecutors fought to resurrect fragments of lost footage. In another, they hit play on voices that never should have been captured. Together, the cases of Zachary Wester and Wayne Jenkins became opposite poles in the same debate. What counts more in the pursuit of truth, what's heard or what's missing? Wester's story began in the silence of wiped memory cards. Each deleted recording symbolized a moment when accountability could have spoken, but didn't. He claimed the malfunctions were routine. Prosecutors disagreed, describing a calculated act of concealment. The absence of footage became the loudest witness in the case, an invisible timeline of guilt. Every missing clip reminded the jury that deletion itself requires intention. Across state lines, technology turned differently against Jenkins. Where Wester hid in erasure, Jenkins drowned in surveillance. His voice, caught without warning on federal wiretaps, provided a running commentary on his team's criminal operations. Each word revealed structure, how raids were planned, money divided, and cover stories rehearsed. The existence of that audio stripped Jenkins of plausible defense. His tone, steady, procedural, almost casual, removed any argument of coincidence. These two evidentiary extremes shaped how modern prosecutors treat digital proof. In Wester's trial, experts dissected timestamps and metadata layers from partially recovered Bodycam files. They described block gaps where deletion signatures appeared, noting inconsistencies in system access logs. The data showed manual tampering rather than error. It forced jurors to confront not only what was missing, but why it was missing. Silence became evidence of corruption. Federal investigators handling the Jenkins case took an opposite route. The audio quality of the wiretap mattered less than its redundancy. Each call was cross-verified across 2 recording systems protected under strict preservation orders. No one in the Baltimore unit could edit or erase those files. That technical precision made the evidence incorruptible. Where local oversight failed in Florida, federal oversight thrived because the data chain was beyond police reach. At trial, forensic analysts from both cases testified to the mechanics of digital integrity. They spoke about checksum validation, redundant storage clusters, and the audit trails that reveal tampering long after data disappears. These tools educate legal systems on preserving chain of custody, vital for upholding statutes like Florida's Section 918.13 and Federal Section 1512 against tampering. These weren't mysterious concepts, they were safeguards written into evidence law. Yet Wester's department had allowed officers administrative permissions that bypassed those safeguards entirely. The loophole was wide enough for deceit to pass unnoticed until someone questioned patterns too strange to ignore. Prosecutors in Florida reframed absence as proof. They argued deletion demonstrated knowledge of wrongdoing, much like flight can indicate guilt under circumstantial evidence standards. Each erased segment, they said, was an act of intent. The courtroom accepted that proposition, turning silence into confession. Across the aisle, federal attorneys had no need for interpretation. Jenkins' wiretap played like a script of self-incrimination. Every laugh on tape functioned as testimony against him. Those dueling realities, one built from vacuum, one from audio saturation, exposed how fragile technological trust can be. Corruption thrives where oversight falters, but evidence endures where access ends. Agencies nationwide responded quickly. Policy revisions introduced third-party audits, firmware locks preventing unauthorized deletion, and cloud-based backups immune to internal manipulation. Federal standards for data authenticity began spreading to state departments that once relied on officer honesty alone. The reconstruction of Wester's deleted footage completed the paradox. Investigators mapped metadata fragments against dispatch records and dashcam overlaps, creating a visual breadcrumb trail of his pattern. When the recovered seconds aligned with arrest patterns, the illusion of malfunction collapsed. Technical absence had evolved into irrefutable presence. His conviction rested not on what video showed, but on what it failed to hide. In the end, those cases reframed digital evidence as both weapon and shield. A missing file could expose deceit as powerfully as a recorded confession could document it. Technology did not lie, access did. What began as sterile forensic analysis became a moral indictment of control itself: who holds it, who abuses it, and who can no longer escape its record. And from this cold machinery, the next chapter moves to something human, the grief left after the truth is finally proven. Courtrooms and communities reeling. What happens to a community when the protectors become predators? Courtrooms, usually sanctuaries of legal ritual, transformed into stages of reckoning. Rows filled with victims who once waited for justice now faced the very officers they had once obeyed. Every word spoken carried the weight of betrayal, a betrayal born not from strangers, but from the same uniforms that symbolize safety. In those rooms, the fragile barrier between lawful authority and criminality fell away, leaving sorrow and disbelief behind. For the families ruined by Zachary Wester's planted narcotics, the courtroom became a place to reclaim names stolen by lies. Mothers and even children took the stand to describe the consequences of false convictions. Jobs lost, custody hearings ended in defeat, a lifetime branded by arrest records that never should have existed. These stem from breaches like his Section 787.02 false imprisonments imposing lifelong stigma beyond prison time. They spoke softly, yet their voices did not need volume to wound. Each testimony detailed years of humiliation for crimes fabricated to serve one man's ambition. The courtroom no longer felt procedural. It bled emotion too heavy for anyone to ignore. Across the eastern seaboard, Baltimore's hearings for Wayne Jenkins and the Gun Trace Task Force mirrored the same human wreckage, but on collective scale. Victims described stop-and-frisk encounters that turned into armed robberies. Witnesses recounted raids conducted without warrants, badges flashed as shields against scrutiny. Then came a single statement that echoed through the federal courthouse. "Do you trust the police department after what your family has been through?" "No, sir." Number. Never. Can anything change that? I don't think so. The stillness after that sentence was its own verdict. It captured the irreversible loss of faith inside entire neighborhoods. Both defendants stood in different postures before the law's judgment. Wester held firm defiance, chin-lifted expression, flat insisting he had been framed, even as video fragments dismantled every denial. Jenkins presented the opposite face of guilt, a subdued man stripped of swagger, murmuring remorse that felt rehearsed. The contrast revealed two versions of corrupted ego, one driven by denial, the other desperate for lenience. In both, remorse arrived too late to meet sincerity. Legal scholars often describe sentencing as both punishment and purification, and these trials embodied that theory. When Wester received 12 years and Jenkins 25, the room exhaled not relief but exhaustion. Justice had functioned mechanically, yet emotionally the damage stretched far beyond the verdicts. The law can punish the body, but it cannot sentence trust. What collapsed during those scandals was not merely procedural compliance, it was citizenship's quiet covenant with authority. Sociologists tracking fallout from these cases documented steep declines in citizen cooperation across jurisdictions. Tip lines went silent. Witnesses hesitated to testify. Patrol cars once viewed as protection began drawing protest lines instead. The word police fractured into two meanings, guardian and threat, depending on who answered the question. Even years later, community surveys revealed a generational echo of mistrust that resisted reform speeches or symbolic apologies. Within those findings lies justice's hardest truth: policy can change overnight, faith cannot. During sentencing arguments, defense attorneys tried to isolate their clients' crimes as personal misdeeds. They warned the court not to condemn entire police institutions for the sins of a few. But prosecutors countered that these acts thrived inside tolerated silence. Without culture, there is no conspiracy. The statement landed because it reflected what residents had already decided: these weren't isolated cases, but symptoms of systemic disdain for accountability. The audience, drawn from neighborhoods repeatedly violated by officers, watched in grim recognition as lawyers debated semantics over systemic rot. Outside the courthouses, protests unfolded with candles and banners instead of gunfire. Each had weaponized authority for acts far darker: kidnapping, rape, child abuse, confirming how boundless the danger becomes when no one questions the badge. In both cities, sentences of life imprisonment brought law's harshest remedy, but not emotional closure. Judges called the pain irrevocable. Communities called it unforgettable. The trials of Wester and Jenkins forced every department to confront what reform really means: not new slogans, but new oversight. Green checkmark reforms educate on statutes like RICO to prevent enterprise-level breaches, rebuilding through mandatory ethics training. Victims, though scarred, began reclaiming dignity through visibility. Some began recording every encounter, not from fear but resolve. Others joined civic boards demanding independent review. Each small act stitched part of the wound closed. Yet beneath those efforts lingers an uncomfortable question about the future of policing. If justice relies on those who once corrupted it, how do you recognize safety again when it starts wearing the same uniform? Corruption inside the badge isn't impulse, it's calculation. Wester's deleted Bodycam files and Jenkins' recorded confessions reveal opposite methods rooted in the same intent: control through deception. Each edit, each whisper mapped the road from uniform to indictment. These crimes didn't just fracture communities, they redefined who deserves belief in a courtroom. The question now turns to you. When betrayal comes from within law enforcement, can trust ever be rebuilt or only replaced by scrutiny? Subscribe and follow Red Tape Red Flag on all platforms. And don't forget to like, share, and comment.